Okay, hello everyone. In this video, as promised, we will be discussing the essential requisites of contracts. As discussed previously in the previous video, the essential elements are those necessary for the very existence of the contract itself, and the absence of any one of these essential elements will prevent the creation or existence of a contract. So what are these essential requisites? We have consent, object, and cause. And let us discuss each of these requisites. To start, we have consent. Consent is defined as the meeting of the minds of the parties on the subject matter and cause of the contract. It is elementary that consent is an essential element for the existence of a contract, and where it is wanting or lacking, the contract is non-existent. It is the essence kasi of a contract. There can be no contract in the true sense in the absence of the element of agreement or of mutual assent of the parties. Consent is a conformity of wills, and with reference to contracts is the agreement of the will of one contracting party with that of another or others upon the object and terms of the contract. The essence of the consent is the conformity of the parties on the terms of the contract, the acceptance by one of the offer made by the other. Uy, may lamok. So, what are the requisites for valid consent? We have, first one, it must be manifested by the concurrence of the offer and acceptance as provided under Articles 1319 to 1326. Okay? Consent is manifested by the meeting of the offer and acceptance upon the thing and the cause which are to constitute the contract. Thus, an offer that is not accepted does not give rise to consent, and the contract does not come into existence. Okay? In terms of the forms of consent, consent may either be expressed or implied. And note that acceptance of the offer may either be expressed or implied. We will go to the different rules of offer, rules of acceptance, and rules of consent after this slide. So the next requisite is that the contracting parties must possess the necessary legal capacity. Okay? The legal capacity. So I think we have a separate slide for the legal capacity. Yeah, I think so. So we will deal with that later, no? And the third requisite for a valid consent is that it must be intelligent, free, spontaneous, and real. So, not vitiated. So, there are also vices of consent that we will be discussing later. So, that is covered under Articles 1332 and Article 1346 of the Civil Code. The concurrence of offer and acceptance. The moment of a meeting of the offer and the acceptance upon the object and the cause that would constitute the contract, consent arises. However, the offer must be certain and the acceptance is seasonable and absolute. If qualified, the acceptance should merely constitute a counter offer. Okay, the concurrence of offer and acceptance. May nag-offer, mayroong nagtanggap ng offer, no? So, what are the different rules on offer? It is provided in Article 1319, Article 1323, Article 1324, Article 1325, and Article 1326. Under Article 1319, the offer must be certain and the acceptance absolute. A qualified acceptance constitutes a counter offer. Okay, so let's take a look at that. No? Offer is defined as an expression of willingness to contract on certain terms, made with the intention that it shall become binding as soon as it is accepted by the person to whom it is addressed. The party who makes the offer, so is called the offeror, while the party to whom an offer is made is called the offeree. So, requisites for effective offer. So, what must be? No? Effective offer. Offer. The offerer must have a serious intention to become bound by his offer. Oo nga naman. Hindi siya serious. Ano na magagawa natin? Next, the terms of the offer must be reasonably certain. Okay? It must be reasonably certain. Offer as certain. Yes, certain period. Okay. The offer must be communicated by the offer to the offeree, resulting in the offeree's knowledge of the offer. When we say seriousness of the offer, under American jurisprudence, we have mutual assent is judged by an objective standard looking to the express words the parties use in the contract. Following the objective theory of contracts, the seriousness of the intention of the offerer is to be determined by what a reasonable person in the offeree's position would conclude the offerer's words and actions meant, and not by the subjective intentions or beliefs of the offerer. Thus, under the objective theory of contract, understandings and beliefs are effective only if shared. Oo nga naman, only if shared. An offer to be effective must be definite, complete, and certain. Okay? It must be definite, complete, and certain. There is an offer in the context of Article 1319, of the Civil Code only if the contract can come into existence by the mere acceptance of the offer without any further act on the part of the offerer. If a new or further agreement is necessary to clarify what has been agreed upon, clearly there is no perfection of the contract. Okay? Tapos, meron tayong communication, Communication of the offer. The offeree cannot accept an offer which has not been communicated to him, and therefore, as a rule, an uncommunicated offer, whether by words or acts, cannot result in a contract. Such uncommunicated offer may be withdrawn at any time. Now, there are certain cases which are not considered as offers. Ito yung advertisements of things for sale. Okay? Unless it appears otherwise, business advertisements of things for sale are not definite offers, but mere invitations to make an offer. The positive response to such advertisement is what may be considered as the offer. However, such advertisement may become an offer if it is expressly and clearly provided therein. How about advertisement for bidders as provided under Article 1326? These are not also considered as offers but simply invitations to make proposals. Hence, as a rule, the advertiser is not bound to accept any bid, whether it may be the highest or lowest, unless the advertisement contains language subject to the interpretation that the intention is to let the contract to the highest or lowest bidder. Here, the bid proposals or quotations submitted by the prospective suppliers are the offers and the reply of the proposer, the acceptance or rejection of the offers. How about in auction sale? In an auction, the auctioneer's call for bids is not considered as an offer, but simply an invitation to make proposals. Here, the bid proposal submitted by the bidder in the offer. Okay? Ordinarily, the sale is considered perfected only when the auctioneer announces its perfection by the fall of the hammer or in other customary manner. Until such announcement is made, any bidder may retract his bid, pwede bawion, and the auctioneer may withdraw the goods from sale unless the auction has been announced to be without reserve. Okay. Now, eto yung communication yung kanina. Yung termination naman ng offer by action of offeror. At any time, prior to the perfection of the contract, either negotiating party may stop the negotiation. The offer, take note, at this stage may be withdrawn or revoked by the offeror as a rule. The power to revoke is implied in the criterion that no contract exists until the acceptance is known. So, cognition theory. No? As a tie or bond springs from the meeting or concurrence of the minds, since up to that moment there exists only a unilateral act. It is evident that he who makes it must have the power to revoke it by withdrawing his proposition. Upon the revocation or withdrawal of the offer, the same is considered terminated. Okay. Revocation, how about it has been revoked, no, prior to the perfection of contract. The contract is perfected only from the time an acceptance of an offer is made known to the offerer. Unless the offerer knows of the acceptance, there is no meeting of minds of the parties, no real concurrence of offer and acceptance. Hence, as a rule, the offerer may withdraw its offer and revoke the same before the acceptance. Take note, ha? Before the acceptance. Okay? Before the acceptance. Paulit-ulit para hindi makalimutan. Before the acceptance thereof by the offeree. But where a period is given to the offeree within which to accept the offer and the same has a separate consideration, take note, a contract of option is deemed perfected, and it would be a breach of the contract to withdraw the offer during the agreed period. The concept of option, this is under the concept of option of contract. Of option contract. Walang off sa gitna. Option contract. So, an option contract is a preparatory contract in which one party grants to the other for a fixed period and under specified conditions the power to decide, no, whether or not to enter into a principal contract. It binds the party who has given the option not to enter into the principal contract with any other person during the period designated, and within that period, mas parang, okay, bibigyan kita ng time para makapag-isip whether or not we go or no, no, parang ganon. To enter into such contract with the one to whom the option was granted if the latter should decide to use the option. Okay? It is a separate agreement distinct from the contract which the parties may enter into upon the consummation of the option. If the transaction is one of sale, an option may be defined as a contract granting a privilege to buy or sell within an agreed time and at a determined price. It is a separate and distinct contract from that which the parties may enter into upon the consummation of the option. Take note that it must be supported by consideration. An option contract conforms with the second paragraph of Article 1479. Take note, guys, or class, its distinguishing characteristic is that it imposes no binding obligation on the person holding the option aside from the consideration for the offer. Until acceptance, it is not, properly speaking, a contract and does not vest, transfer, or agree to transfer any title to or any interest or right in the subject matter, but is merely a contract by which the owner of a property gives the optionee the right or privilege of accepting the offer and buying the property on certain terms. Okay? So, these are the rules on offer. Doon pa tayo sa consent kasi kinakailangan there is a concurrence of offer and acceptance. So, these are the rules on offer. Now, let's proceed to the rules on acceptance. Okay? Which are covered under Article 1319, 1320, 1321, and Article 1322. Dito sa 1319 kasi ito is yung offer daw certain, which is yung sa rules on offer. And then, of course, yung sa rules on acceptance, the acceptance must be absolute. No? A qualified acceptance constitutes a counter offer. Okay. By the way, there is one that yung, balikan muna natin yung ito. An offer becomes ineffective upon, parang hindi natin ito na-discuss, upon the death, civil interdiction, insanity, or insolvency. The contract is perfected only from the time an acceptance of an offer is made known to the offerer. If prior thereto, either party dies, suffers from civil interdiction, nabuang, becomes insane or insolvent, the offer is rendered ineffective. In other words, the disappearance of either party or his loss of capacity before perfection prevents the contractual tie from being formed. So, these are effects, no? Effects. Effect of death, civil interdiction, insanity, or insolvency. Take note of either party before acceptance is conveyed. Anong mangyayari? Prevents the contractual tie from being formed. Okay. Now, let's go sa go on the rules on acceptance. Okay. To produce a contract, there must be acceptance, which may be expressed or implied, but must not qualify the terms of the offer. Where there is merely an offer by one party without the acceptance of the other, there is no consent. So, di pa mo uyab, anak. Kung nag-offer pa siya, uyab na ta, tapos wala naman siya gisugot, so wala pag-acceptance, wala consent, right? An acceptance concludes the making of a contract. Nothing further is required. The effect of an unqualified acceptance of the offer is to perfect a contract. An agreement presupposes a meeting of the minds, and when that point is reached in the negotiations between the parties intending to enter into a contract, the purported contract is deemed perfected, and none of them may thereafter disengage himself therefrom without being liable to the other in an action for specific performance. Now, sabi ko nga, the acceptance must be absolute. There must be no condition or qualification. Walang pero. Okay? Only an absolute or unqualified acceptance of a definite offer manifests the consent necessary to perfect a contract. To convert the offer into a contract, the acceptance must be absolute and must not qualify the terms of the offer, and that it must be plain, unequivocal, unconditional, and without variance of any sort from the proposal. No? Pwede nga, okay, can I buy this, let's say for example, a cell phone, I'm selling this to you at 10,000 or 15,000, 15,000. And then, okay, you said, yes, okay, I'll buy it at 15,000. Okay, so that is your acceptance. But when you say that, can you lower the price to, let's say, for example, 13,500? Yun lang kasi yung pera ko eh. So, you are not yet accepting, or there is no meeting of minds yet, no? So, you are doing like, may counter offer ka pa dun sa 15,000 na offer niya. So, if that would be the case, there is still no acceptance, no? Counter offer pa lang yun. So, kinakailangan that the acceptance must be absolute and must not qualify the terms of the offer. Now, what would be the effect of qualified acceptance? Yung qualified acceptance. A qualified acceptance, or one that involves a new proposal, constitutes a counteroffer and is a rejection of the original offer. Consequently, when something is desired which is not exactly what is proposed in the offer, such acceptance is not sufficient to generate consent because any modification or variation from the terms of the offer annuls the offer. In other words na ulit, a proposal to accept or an acceptance introducing new conditions or terms varying from those offered amounts to a rejection of the offer and the submission of a counter-proposal and puts an end to the negotiations without forming a contract unless the party making the offer renews it or agrees to the suggested modifications. Okay. Yun na yun. Now, meron tayong tinatawag na mirror image rule. This rule is a common law concept which states that in order for there to be an acceptance, the offeree must accept the terms as stated in the offer. Our courts are likewise adhering to the mirror image rule. Thus, it has been ruled in this jurisdiction that the acceptance must be identical in all respects. No? with that of the offeror so as to produce consent or meeting of the minds. Mirror image rule. Na kailangan parehas lahat. Okay? Manner and form of acceptance. An acceptance may be expressed or implied. Diba? In his offer, the offeror also may fix the time, place, and manner of acceptance, all of which must be complied with. If an offeror prescribes the exclusive manner in which acceptance of his offer shall be indicated by the offeree, an acceptance of the offer in the manner prescribed will bind the offeror. On the other hand, an attempt on the part of the offeree to accept the offer in a different manner does not bind the offeror, as the absence of the meeting of the minds on the altered type of acceptance. If the parties intended that there should be an express acceptance, the contract will be perfected only upon knowledge by the offeror of the express acceptance by the offeree of the offer. An acceptance which is not made in the manner prescribed by the offeror is not effective but constitutes a counteroffer which the offeror may accept or reject. Now, forms. Ito pala yung forms of acceptance. It may be expressed or implied. No? The rule is that except where formal acceptance is so required, although the acceptance must be affirmatively and clearly made and must be evidenced by some acts or conduct communicated to the offerer, it may be made either in a formal or an informal manner, and may be shown by acts, conduct, or words of the accepting party that clearly manifest a present intention or determination to accept the offer. Thus, acceptance may be shown by the acts, conducts, or words of a party recognizing the existence of a contract. But if the parties intended that there should be an express acceptance, the contract will be perfected only upon knowledge by the offerer of the express acceptance by the offeree of the offer. What could be a nice example for this one? Okay. A phone. You sell it at 15,000. Same lang, no? Huwag na nating guluhin yung mga isip natin. So, 15,000. Hindi pa siya nag-set ng yes, pero nabigyan na siya ng 15,000 pesos. By his acts, no? By giving you that 15,000 pesos, it is as if he gives his consent, no? So, there is already meeting of minds. Assuming hindi mo naman siya, ano ba tawag doon? Hindi mo naman siya pinilit, no? Na bigyan ka ng 15,000, no? If an offer naman, an offer made through an agent is accepted from the time the acceptance is communicated to him. So, if an offer has been made through an agent, no, it is deemed accepted. Since by legal fiction, the agent is the extension of the personality of the principal. In other words, one who makes an offer through a particular channel or agency impliedly authorizes an acceptance through the same channel or agency. This is the rule unless the contrary is provided in the terms of the offer. Now, let's proceed with yung rules of acceptance. Rules on consent. Kasi yung una, rules on offer and rules on acceptance. Now, what are then the rules of consent? Take note, the parties must have the capacity to enter into a contract. Second, contracts agreed to in a state of drunkenness or during a hypnotic spell are voidable. No? Meaning, is one voidable contract, yung one of the defective contracts, which will be discussed in another video. And then, a contract where consent is given through mistake, fraud, violence, intimidation, undue influence, or fraud is voidable. Ito naman yung mga vices of consent, which will be discussed, slide after this one, I think. So, the legal capacity of the parties is an essential element for the existence of the contracts because it is an indispensable condition for the existence of consent. There is no effective consent in law without the capacity to give such consent. In other words, legal consent presupposes capacity. Now, what would happen what would be the effect of incapacity upon the contract? The contract is not void. Okay? If only one of the contracting parties is incapable of giving consent to a contract, the same is merely voidable. However, where both parties are incapable of giving consent to a contract, the same is forcible. Tingnan nyo ha kung sino ba yung walang kakayahan magbigay ng consent. So, who are then, what are the examples or who are these people or persons incapable of giving consent? You have the unemancipated minors, insane or demented persons, deaf mutes who do not know how to write, persons suffering from civil interdiction and incompetence under guardianship. There is a presumption of capacity. No? The law presumes that every person is fully competent to enter into contract until satisfactory proof to the contrary is presented. The burden of proof is on the individual asserting a lack of capacity to contract, and this burden has been characterized as requiring for its satisfaction clear and convincing evidence. 1. Yung minority. Minority is defined as the state of a person who is under the age of legal majority, and a minor is a person below 18 years of age, since majority commences upon attaining the age of 18 years. What would happen? No? Ano mangyayari if he entered into a contract? A contract entered into by a minor is not void, take note, but merely voidable. The law gives the minor the right to annul the contract entered into by him upon his attainment of the age of majority. But he must bring, so meron tayong parang time frame kung kailan niya kinakailangan na i-bring ang action sa court, no? Within 4 years from his attainment of the age of majority. Otherwise, the action will be barred by the statute of limitations or prescription. He may, however, ratify the voidable contract upon reaching the age of majority. 4 years lang, no? 18, 20, 21, 22. Hindi din pwede na lifetime, no? Pwede niya ma-raise na, minor ako nung binigay ko yung consent na yun. So, dapat hindi pala ganun. O, diba? Hindi pwede na lifetime. 4 years lang po. 4 years. How about where the minors who entered into the contract have already passed the age of puberty and adolescence in such a way that they could misrepresent and actually did misrepresent themselves as having reached the age of majority? They cannot, upon reaching the age of majority, annul the contract on the ground of minority inasmuch as they are already in estopel. Yung mukhang matanda, pero bata pa pala, charot. But this ruling applies only if the minor was guilty of active misrepresentation, as when the document signed by the minor specifically stated that he was of age. Thus, if the minor was guilty merely of constructive or passive misrepresentation, or when the document signed by him did not contain such statement, he may still annul the contract upon reaching the age of majority. Where the minor did not pretend to be of age at the time when the contract was made and his minority was well known to the other party, the contract may still be annulled. Okay. How about yung parang insane? Hindi parang talagang naging baliw. No? Insanity is a manifestation in language or conduct or of disease or defect of the brain, or more or less permanently diseased or disordered condition of the mentality, functional or organic, and characterized by perversion, inhibition, or disordered function of the sensory or of the intellective faculties, or by implied or disorder volition. Now, what would be the effect? Ano yung effect ng insanity upon the contract? It's not void, but merely voidable. Same lang sa minority ng effect, no? Not void, but merely voidable. But if the contract is entered into during a period of lucid interval, yung nasa yung tamang pag-iisip, no? The same is valid. So, lucid interval is that intervals occurring in the mental life of an insane person during which he is completely restored to the use of his reason, or so far restored that he has sufficient intelligence, judgment, and will to enter into contractual relations or perform other legal acts without disqualification by reason of his disease. No? Yung meron pa tayong presumption nun, nasa tamang pag-iisip ka yung in-enter mo yung contract enter, yung, when you drafted, you perfected, merong presumption ng sanity. But, of course, that is irrebuttable. Pwede naman din yung presumption, rebuttable presumption. No? There is a presumption, it can be rebutted. This presumption of sanity is not, however, overthrown by the fact that 9 days after the execution of the contract, the vendor was declared mentally incapacitated by the court. Of course, sino may yung may burden of proof na incapacity at the time of the execution of the contract? It rests upon he who alleges it. If no sufficient proof to this effect is presented, his capacity will be presumed. Okay? If the contracting party, on the other hand, is under a guardianship by reason of insanity, there is naturally a presumption of insanity. This presumption of insanity is, however, only prima facie and may be rebutted by evidence. Thus, it may be shown that he executed the contract during lucid intervals. Sabi mo, nasa tamang pag-iisip siya yung pinirmahan niya to. Pero hindi pala. So, depende yun, no? Okay. We also have civil interdiction, accessory penalty imposed upon an accused who is sentenced to a principal penalty not lower than reclusion temporal, which is a penalty ranging from 12 years and 1 day to 20 years. Civil interdiction deprives the offender during the time of his sentence, nandun sa kulungan, ng parental authority, guardianship, either as person or property of any ward, marital authority, management of his property, and disposition of his property by any act or any conveyance inter vivos. Thus, a person suffering from this accessory penalty may not validly enter into contracts involving disposition of his property if the same will take effect during his lifetime. Okay. Effect ng old age. A person is not incapacitated to contract merely because of advanced years or by reason of physical infirmities. Only when such age or infirmities impair his mental faculties to such extent as to prevent him from properly, intelligently, and fairly protecting his property rights that he is considered incapacitated. Okay. Yung mistake, fraud, violence, intimidation, and influence of fraud, voidable yon. Pero meron tayong mga nilagay dito na ano ba yung mistake? Mistake. These are the 5 vices of consent. First one is mistake. In order that mistake may invalidate consent, it should refer to the substance of the thing which is the object of the contract, or to those conditions which have principally moved one or both parties to enter into the contract. Violence, yung serious or irresistible force used to wrest consent. Intimidation, one of the contracting parties is compelled by a reasonable and well-grounded fear of an imminent and grave evil upon his person or property or upon the person or property of his spouse, descendants, or ascendants to give his consent. Let's say, for example, grave evil upon his person, sabi niya. Mamaya na lang. Yung sa mga voidable contract na lang yun natin i-discuss yung intimidation ang in-depth, no? Undue influence, yung when a person takes improper advantage of his power over the will of another, depriving the latter of reasonable freedom of choice. Ito yung manayari if, for example, yung boss mo, or let's say, yung may power or authority, no? Example, sa barangay, no? Dapat sabi nila, kinakailangan mo ibigay ito, kundi hindi ka mabibigyan ng mga ganito, ganyan. So, meron siyang power over you. Ginamit niya yung power niya para ibigay mo yung consent. Like, napupush ka kasi, uy, powerful individual to so, baka hindi ako magkaroon ng ganito, hindi ako mabigyan ng ayuda, just in case, hindi ko siya bigyan, parang favor, no? And then, fraud, when through insidious words or machinations of one of the contracting parties, the other is induced to enter into a contract which, without them, he would not have agreed to. So, niloko mo siya, no? Yung fraud. So, next, punta naman tayo sa second essential, no, parang yung first essential requisite pa lang, inabot na tayo ng, my God, mga 30 minutes. So, punta na tayo ng object of contracts, no? Object is the subject matter, the thing, right, or service, which is the subject matter of the obligation arising from the contract. What may be the object of contracts? The following, all things which are not outside the commerce of men, including future things, all rights which are not intransmissible, or all services which are not contrary to law, morals, good customs, public order, or public policy. Okay. Requisite 1347, 1348, 49, yung requisites of object of a contract for a thing, right, or service to be an object of contracts. The following requisites must concur. to, dapat these are not outside the commerce of men. It must not be impossible, no? Must be real or possible either physically or legally. And it must be licit or not contrary to law, morals, good customs, public order, or public policy. Okay. Objects which are within the commerce of men. In order to be considered as within the commerce of men, the object should be susceptible of appropriation and it should be transmissible from one person to another. Thus, the following are outside the commerce of men and may not therefore be the object of contracts. First one are those sacred or common things like the air or the sea, no? Common things, mahirap din naman yun. Binibenta na yung hangin ngayon, hindi, di ba? So, next, property while they pertain to the public dominion, such as public or town plaza. Hindi mo yan pwedeng gamitin as an object of a contract. Rights which are purely personal, therefore intransmissible. Okay, like status and capacity of persons and honorary titles and distinction. Public offices, no, inherent attributes of the public authority and political rights of individuals, such as the right of suffrage, services which, and finally, services which imply an absolute submission by those who render them, sacrificing their liberty, their independence or beliefs, or disregarding in any manner the equality and dignity of persons, such as perpetual servitude or slavery. And ikaw magiging katulong ko, alila ko hanggang sa walang hanggan. Requisites, no, isa yon. So, dapat kinakailangan all things which are not outside the commerce of men. Okay. The object must be in existence at the time of the perfection of the contract, or at least it has the possibility or potentiality of coming into existence. Thus, meron tinatawag yung mga future things, including future things may be the object of contract. Donation, however, cannot comprehend future things because it is a mode of transferring ownership. Okay. Impossible. Ito naman, impossible things cannot be object of contracts. With respect to service, the impossibility may either be absolute impossibility wherein nobody can perform it. No? An absolute impossibility nullifies the contract, and a contract which contemplates of an impossible service is void. Wala makakagawa niyan, besh. Effect of relative impossibility. The service is relatively impossible when due to the special conditions or qualifications of the debtor, it cannot be performed. Relative impossibility, if temporary, does not nullify the contract, such as when the partner agrees to contribute to the partnership a sum more than what his means allow. But if the relative impossibility is permanent, then it nullifies the contract, such as blindness in contract which requires the use of eyesight. Hindi ko magagawa. And finally, the object of every contract must be determinate as to its kind. The fact that the quantity is not determinate shall not be an obstacle to the existence of a contract, provided it is possible to determine the same without the need of a new contract between the parties. It is sufficient that the object of the contract be determinable at the time of the perfection of the contract. And finally, ito na talaga yung pangatlo, no? Pinakalas na sa essential requisites sa video na to. Kasi, yeah, it's time to sleep. Charot. Hindi pa naman. Cause, the essential and impelling reason why a party assumes an obligation. Bakit? Bakit ba? Ano ba? So, the consideration is the why. Ito yung why. Bakit? It is the essential reason which moves the contracting parties to enter into it. It is the immediate, direct, and proximate reason which justifies the creation of an obligation through the will of the contracting parties. If you could still remember, yung contract according to cost, no? Yung onerous, remuneratory, gratuitous. What are then the requisites, no? It must exist, it must be lawful, it must be true. And I know parang If ikaw yung estudyante, feel mo, sana ito lumabas sa quiz. Kasi ang dali-dali lang i-memorize. It must exist, it must be lawful, and it must be true. If a contract has no cause, it does not produce any effect whatsoever and is inexistent or void from the beginning. The law says that a contract whose cause did not exist at the time of the transaction is void from the beginning. Of course, it must be lawful. No, it must be lawful. Ang hirap din naman kung hindi pwede, hindi lawful, no? It must be true, it must be lawful. There is want of cause when there is no consideration, whatever, or there is total absence of consideration. Want or lack of consideration is different, however, from failure to pay the consideration. No? Iba yung wala kang binigay or hindi ka pa nakapagbigay. Okay? The latter results in a right to demand the fulfillment or cancellation of the obligation under an existing valid contract, while the former prevents the existence of a valid contract. Of course, the statement of a false cause in contract shall render them void unless it can be proven that they were founded upon another cause which is true and lawful. If the price is simulated, the sale is void. But the act may be shown to have been in reality a donation or some other act or contract. Hence, a deed of sale in which the stated consideration had not in fact been paid is null and void. Yung lawful, no? A contract where the cause is contrary to law, morals, good customs, public order, or public policy is void and produces no effect whatsoever. However, although the cause is not stated in the contract, it is presumed that it exists and is lawful unless the debtor proves the contrary. I think I saw. And I think, yeah, this would be the end of the session. Same instruction. If you have questions, clarification, you can write it down and then we'll discuss it during our synchronous class discussion now. So, of course, I'll be posting a short quiz in Google Classroom after this video. Okay. And I'll just keep you posted. Thank you very much and have a good day. Keep safe, everyone. Bye.